Our major case on point for the evaluation of complaints and the evolving definition of Rule 8 is Iqbal v. Ashcroft. Iqbal v. Ashcroft is a case litigated in the wake of 9/11, the terrorist attacks of 2001. And the allegations there were that federal officials, and specifically John Ashcroft, who was then Attorney General, and Robert Mueller, who was then the head of the FBI, instigated and directed a racially, ethnically, and religiously discriminatory program of basically rounding up Muslim men of Arab heritage, especially in New York City, but other places as well, without really requiring any specific connection to a terrorist threat or suspicion of terrorist activity. So the plaintiffs in Iqbal, one of the things they were claiming was that they were arrested in a way that discriminated against them in ways that are prohibited under the Constitution. Iqbal did not start out as a case about complaint standards. And so although what we're going to talk about in class is the complaint standard that Iqbal sets out, I think it's important to understand the context in which it arose and what the case itself was about. And this also allows us to discuss an aspect of civil procedure that doesn't really make it that much explicitly into our casebook or our class, but is increasingly politically salient, and is an important aspect of procedure in the sense that it's a way that people can get out of being sued, irrespective of the merits of the case, and that's called immunity. So let me show you the question presented in Iqbal when it went up to the Supreme Court. So notice this doesn't say anything about Rule 8 standards, except kind of obliquely. So the question is whether a supervisory official sued as an individual defendant, so they're talking about Ashcroft and Mueller, in a Bivens action, is entitled to qualified immunity when the plaintiff pleads only generalized and conclusory allegations in his complaint and asserts no specific facts as to that supervisory official. So you can see echoes of Rule 8 here in the generalized and conclusory allegations, and you can also see echoes of Twombly here, right? They're drawing on the Twombly case. But the thing that the cert petition actually asked about was qualified immunity in Bivens actions. So let me talk about that, even though in class we'll be focusing on the Rule 8 issues. First of all, Bivens actions we've already discussed a little bit. That is the Supreme Court holding that allows you to sue a federal employee for a violation of your federal rights. Bivens was a case in 1971 that allowed a person to sue employees of the Drug Enforcement Agency for a violation of his Fourth Amendment rights, despite there not being a statute that gave him an explicit cause of action for the lawsuit. So in contrast to 28 U.S.C. 1983, which we've already seen in play in Fuentes, which allows you to sue state employees for violations of federal rights. So that's a federal statute. There is no federal statute allowing you to do that with federal employees, but there is Bivens, which allows you to do it. So that's one part of the question, right? You'll recall the cert petition asked about qualified immunity in Bivens cases. So this is a Bivens action against federal employees, the Attorney General and the Director of the FBI. Are they subject to qualified immunity from suit? So the idea behind qualified immunity is to allow government agents to do their jobs without worrying about being liable in a lawsuit if they make a mistake. And what qualified immunity does is it offers qualified immunity from suit. So it immunizes the government official from the burdens of litigation. This doesn't mean that they are innocent in a colloquial sense. It doesn't say anything about the merits, but it does say that you can't sue them. You can't go through a discovery process and you cannot recover anything, regardless of how the merits are, because they are immune from suit. It's called qualified immunity in contrast to the absolute immunity enjoyed, for instance, by judges. So if a judge rules against you in a case, you cannot sue the judge for harming you. And you basically can't sue a judge for doing anything that is in the course of their duties. That's absolute immunity. Qualified immunity is supposed to be qualified because it only kicks in under certain circumstances, and I'll talk about those in a sec. So this is a doctrine that sounds kind of ancient, but actually was initiated by the Supreme Court in certain limited circumstances in the 1960s, but has expanded really quite dramatically since then, both in the scope of the circumstances to which it applies, and in the breadth of immunity that it affords, so that qualified part of qualified immunity has gotten smaller and smaller over time. And here's why. So the requirements to have qualified immunity from suit are that the plaintiff can plead that the government official violated some statutory or constitutional right. So just like in a normal complaint, you need to have enough of factual allegations to suggest that your federal right has been violated. And that right has to have been clearly established at the time that the challenged conduct occurred. So when the idea of clearly established rights was initiated in this line of cases elaborating qualified immunity, it was fairly general, fairly broad, and the idea was that courts do create rights or find rights to be expanded under constitutional protections in their opinions, right, in ways that we've talked about, where courts contribute to the construction of the law in this country under our common law system. And it's not fair to say you violated a right that didn't exist at the time that you acted, or that may have existed incipiently, but that wasn't recognized as a right at that time. However, the idea of a clearly established right has really grown over time. So Harlow in 1982 described it as a right is clearly established if every reasonable official in the defendant's place would have understood that their action violated the right. But at this point, in order to establish that a right was clearly established, the plaintiff really has to find a case pretty much directly on point in an opinion saying this right is clearly established. And so you find qualified immunity granted even when the basic contours of a right, to be free of search and seizures that are unreasonable or something like that, the basic contours are pretty clear. But this particular factual situation in which this plaintiff finds themselves has not occurred in litigation before, and a court has not said that your right against an unreasonable search or seizure, even though your right against, let's say, an unreasonable search or seizure is clearly established against, say, a police officer who leans into your car and shoots at you without provocation. It may not be clearly established if the police officer is sitting in the car with you and you are driving. So that's a recent case in which the court found qualified immunity because the right of the driver to be free of unreasonable search or seizure when an officer entered his car without asserting probable cause, without identifying himself as an officer, and shot him when the driver tried to drive away with the officer in the car, that wasn't clearly, that the driver's right in that case was not clearly established because there wasn't a specific case on point where an officer was in the car being driven by a driver whom he shot. So a classic way of describing this is that qualified immunity is supposed to protect all but the plainly incompetent or those who knowingly violate the law. That's a quote from 1986. I think at this point there's at least some argument that qualified immunity actually extends its protections even further than this. And there's a ton of scholarship being done on this now. Or I should say, there's a really high quality of scholarship being done on this now. If you're interested in learning more, I'd especially recommend Joanna Schwartz, who's studied qualified immunity from every possible perspective, and the practical implications, the way it plays out in local police departments, and the legal doctrine. There's a couple of other arguments and articles worth looking at. There's William Bod, who wrote a nice legal examination that's called Is Qualified Immunity Unlawful? And Chris Walker, who offers a qualified defense of qualified immunity. So I'll put these two and selections from the Joanna Schwartz opus over on UB Learns for those who are interested in learning more about this. Qualified immunity has also been the object of some legal activism, with a couple of states eliminating qualified immunity for state law issues, and some attempts at the federal level as well, so far without success. But if that were to pass through Congress and the president to become a federal statute, then courts evaluating federal claims would also not be able to use qualified immunity. At this point, maybe it's worth stopping for a second and saying, hey, hold on, how can they do that? These are rules that judges use to determine whether somebody can sue. How can we outlaw the use of that rule by statute? Don't you need a court, the Supreme Court, to reverse itself on qualified immunity? And the answer lies in the relationship among sources of authority. So just a quick review. Qualified immunity is a common law doctrine. In other words, it is judge-made rules, and judges can make legal rules to some extent under our common law system, but those judge-made rules can be overcome by statute. So if the state passes a statute or if the federal government passes a statute, that becomes the law, and whatever the judges decided to do before that is no longer operable. And of course, both of these things must conform to the Constitution. So just keep that in mind when you hear discussions about this. The legislature, bound by the Constitution, does get the final say on stuff like qualified immunity, which is why legal activism in this field is really fertile ground and worth pursuing.